What we might know informally as child molestation is covered under the Texas Penal Code offense of indecency with a child. There are several types of situations covered under this statute. The first type of indecency with child involves an adult engaging in sexual contact with a child younger than 17. The Penal Code defines contact as any touching of the anus, breast, or any part of the genitals of another person. This offense may occur over or under the clothing of the child and may be informally referred to in the court as indecency by contact. This particular offense is a felony of the second degree. The next type of indecency with child is committed when a person, with intent to arouse or gratify sexual desire, exposes his or her anus or any part of his or her genitals knowing a child younger than 17 is present. Keep in mind, this isn't just exposing yourself. It's exposure combined with the intent to arouse or gratify sexual desire. This particular part of the offense may be referred to informally in the court as indecency by exposure. This type of indecency with child also involves an adult who causes a child younger than 17 to expose his or her anus or any part of their genitals, again with the intent to arouse or gratify sexual desire. These two types of indecency with child offenses are felonies of the third degree. The final type of indecency with a child occurs when an adult causes a child younger than 17 to engage in sexual contact with another. This type of indecency with child is a felony of the second degree. This statute states these offenses are committed regardless of whether the actor knew the age of the victim at the time of the offense. This means the mistake of fact offense, or essentially a defendant arguing, "I didn't know the child wasn't 17," or "I thought the child was 17," may not be used. The offense is committed regardless of the defendant's knowledge of the age. Now, the Penal Code recognizes sexual activity between two age-appropriate consenting teenagers would be considered criminal the way this statute is written, so it sets out an affirmative defense to help distinguish between a situation such as these acts occurring between, say, a 16-year-old and a 28-year-old, which is clearly inappropriate, and a situation of these acts occurring between a 16-year-old and an 18-year-old, which is far more acceptable. This affirmative defense is sometimes informally referred to as a Romeo and Juliet defense in criminal law. The Penal Code states it is an affirmative defense to indecency with child if there is 3 years or less age difference between the persons, no duress, force, or threat was used, and the actor was not a registered sex offender or the actor was the spouse of the child.